Mr. Halpern, you've been appointed to represent Ms. Murray, is that correct?
Yes, Your Honor.
All right, you prepared for arraignment now?
Yes.
Commonwealth ready?
Yes, Your Honor.
All right, Mr. Clerk.
Indictment 14-1393, count 1, charging murder. The jurors of the Commonwealth of Massachusetts on their oath present that Erika Murray, dates unknown, at Blackstone in the county of Worcester aforesaid, did fail to perform her legal duty as a parent to provide for the care and welfare necessary for the survival of baby Rivera No. 1, despite the ability to do so, and by said failure created a plain and strong likelihood of death for baby Rivera No. 1, resulting in the death of baby Rivera No. 1. To this indictment, how do you plead, guilty or not guilty? Indictment 14-1393, count 2, charging murder. The jurors for the Commonwealth of Massachusetts on their oath present that Erika Murray, dates unknown, at Blackstone in the county of Worcester aforesaid, did fail to perform her legal duty as a parent to provide for the care and welfare necessary for the survival of baby Rivera No. 2, despite the ability to do so, and by said failure created a plain and strong likelihood of death for baby Rivera No. 2, resulting in the death of baby Rivera No. 2. To this indictment, how do you plead, guilty or not guilty?
Not guilty.
Indictment number 3, charging assault and battery on a child with substantial bodily injury. How do you plead, guilty or not guilty?
Not guilty.
Indictment number 4, charging assault and battery on a child with substantial bodily injury. How do you plead, guilty or not guilty?
Not guilty.
Indictment number 5, reckless endangerment of a child. How do you plead, guilty or not guilty?
Not guilty.
Indictment number 6, reckless endangerment of a child. How do you plead, guilty or not guilty?
Not guilty.
Indictment number 7, cruelty to animals. How do you plead, guilty or not guilty?
Not guilty.
Indictment number 8, cruelty to animals. How do you plead, guilty or not guilty?
Not guilty.
And indictment number 9, concealing fetal death. How do you plead, guilty or not guilty?
Not guilty.
Issue of bail?
Yes, Your Honor. May I be heard?
Yes.
By way of background, Your Honor, the defendant was held on $1 million cash bail in the Uxbridge District Court. At that time, however, she was not charged with the offenses of murder. Now that a grand jury has indicted her twice for the offense of murder, the Commonwealth is requesting that she be held without bail. By way of a factual background, in August of this year, this defendant lived at an address 23 St. Paul Street in the town of Blackstone. And as far as the outside world knew, she lived there with her longtime boyfriend, Raymond Rivera, and 2 children, a 13-year-old girl and a 10-year-old boy. On the afternoon of August 28th of 2014, the 10-year-old boy was playing with a friend from the neighborhood. And late that afternoon, the 10-year-old's friend called his mother and asked his mother if she knew how they could get a baby to stop crying. After a brief conversation, the mother drove to the home, entered the home, and was appalled by what she observed. The aroma of feces, according to the mother who lived in the neighborhood, was overwhelming. She proceeded up a staircase where the only bedrooms in the home were located. There were 3 bedrooms in the home. When she reached the top of the staircase, she veered to her right where there were 2 bedrooms located. And she ultimately observed small children, 1 small child in each bedroom. In the bedroom to the left, she observed what would ultimately prove to be a 3-year-old girl. According to the neighbor, the 3-year-old appeared to be covered in feces. The room she was in was completely filled with trash that was piled about 2 feet high, and the 3-year-old girl was wearing a soiled diaper, and she was crying. The neighbor then went to the bedroom immediately to the right, where she observed what would ultimately prove to be a 6 or 5.5-month-old girl. Similarly, this small child was covered in feces. She was wearing a soiled diaper, and the room she was in, while not as dirty as the room to the left, was nevertheless dirty. There were stacks of soiled diapers that were piled about a foot or so high in that room. The neighbor immediately called the police. She dialed 911. The police responded to the home. The Department of Children and Families responded to the home. And ultimately, the home was ordered condemned by the Board of Health. This defendant appeared at the home after a short period of time and admitted that she had left the 3-year-old and the 6-month-old in the sole custody of her 10-year-old son. The police and the Department of Children and Families proceeded to remove the 2 small girls from the home. The Department of Children and Families took custody of them, and as I said, the home was condemned. This defendant told the police that the 3-year-old and the 6-month-old were her children and that they had been born at Milford Hospital. A check at Milford Hospital would later prove that that was not true. Milford Hospital had absolutely no record of these 2 small children being born there. The defendant would later that afternoon telephone her boyfriend, Raymond Rivera, and tell him that the home had been foreclosed on by the bank and that the older children had been taken by the Department of Children and Families because there was nobody else to care for them. The police would then conduct an investigation in an attempt to find out who these 2 small children were, the 3-year-old and the 6-month-old. A search warrant was executed at the home on September 10th. And in an effort to locate some paperwork, a birth certificate or something to indicate who these small children were, the police conducted a search. When they searched the upstairs portion of the house, in the bedroom to the right where the 6-month-old girl was found, just inside a closet, the only closet in that bedroom, they found a dead baby. The baby was wrapped in a pair of sweatpants. The baby still had the umbilical cord and the placenta attached to it and had what appeared to be a full head of hair. At that point, the police decided that they needed to obtain another search warrant, which they did and ultimately executed the very next day on September 11th. When the police went back inside the home, inside that same bedroom where they found the dead baby, and in that same closet, they found a second dead baby. This dead baby consisted of skeletal remains. However, the baby was clothed. The baby was wearing a diaper and a onesie. The police then searched the other bedroom, the adjoining bedroom, where the 3-year-old girl was found. And inside the only closet in that bedroom, inside a cardboard box, they found a 3rd dead baby. This dead baby also consisted entirely of skeletal remains. This dead baby was also clothed. The baby was wearing a diaper, a onesie, was wrapped in a blanket, and actually had a pair of socks on it. This defendant was questioned by the police on September 10th after the first dead baby was found. When asked about whether there would be any more dead babies found in the home, she lied, and she told them that there would be no more dead babies found in the home. When she was questioned again by the police on September 11th after the other 2 dead babies were found, she eventually admitted that one of the babies had been alive for a period of time. She specifically told the police that one of the babies, which she thought to have been a girl, had lived in the home for a period of about 1 to 3 weeks. The medical examiner's office, Your Honor, determined that the 2 clothed dead babies were full term. And in addition, the grand jury heard testimony from a witness that there were 3 babies living in the home during a period of time from about 4 to 6 years ago. That those babies were inside the bedroom to the left when you walked up the stairs to the right, and that was the bedroom that was piled high with trash, about a foot or so of trash, and that those babies were inside the home for a period of time from about a week to a month. All the evidence, Your Honor, before the grand jury has suggested that this defendant had 5 children within a 7-year time period. The defendant admitted to the police that she knew that her boyfriend did not want any more children after the first 2, the 13-year-old and the 10-year-old, and that they could not afford to have any more children. The evidence before the grand jury has suggested that the defendant nevertheless continued to have unprotected sex with her boyfriend, and that when these babies were born, and she told the police that she had all of the babies inside the only bathroom of the house, which was located on the first floor, that she had no medical intervention whatsoever, that she birthed the children herself in that sole bathroom in the home, and that the children were placed inside that trash-filled bedroom in an effort to hide the babies from her boyfriend. The 2 younger living children were examined at UMass Medical Center here in Worcester, and they were found to be profoundly neglected by the pediatrician. The 3-year-old could neither walk nor talk. She had basically no muscle tone. She was severely malnourished. In addition, the 3-year-old, when she was first run through a battery of tests by the pediatrician, she appeared as though she had severe hearing difficulties. The pediatricians had to literally clean the maggots out of her ears so that she was able to hear correctly. The 6-month-old similarly was severely malnourished, and it appeared to the pediatricians as though she had spent the majority of her young life on her back. The evidence before the grand jury has suggested, Your Honor, that all of the children given birth to by the defendant were placed in this trash-filled bedroom and literally isolated in their own home. This bedroom was filled with trash. There was feces smeared upon the walls of the bedroom, and it appears that the children were neither nourished, cared for, or literally brought out of that bedroom into the rest of the house or the rest of the outside world. We would suggest that based on the nature and circumstances of the case, based upon the fact that the defendant is now facing 2 murder indictments, that she should be held without bail during the pendency of this case.
Mr. Halpern?
I do. Your Honor, if a decision regarding bail was going to be made based on the issue of risk of flight, there would be no need for any cash amount because Ms. Murray poses absolutely no risk of flight. She grew up in Northbridge, lived there until she moved to the house in Blackstone. Those are the only 2 places she'd lived her entire life. She's been out of the state beyond going on car trips to Rhode Island or New Hampshire once in her life to Florida. She's never been out of the country. She doesn't have a passport. And at this point, her photograph has been seen in hundreds of newspapers, not just in this country. It's inconceivable that she would go anywhere. And if the court were open to the possibility, there is a place where she could stay on electronic monitoring, a relative that I would discuss at sidebar to keep the identification from the media. With respect to the charges, shortly after, within days of the initial search of the home, the district attorney spoke about the need to wait and see what evidence was brought forward, talked about there being many unanswered questions that needed time to be resolved, talked about the importance of waiting for the medical examiner's findings. What's changed? The medical examiner's report has not been issued. I haven't been provided with it. I know what the medical examiner witness testified to in the grand jury only because I've been told by the district attorney's office, and my understanding is that he testified that it was impossible to determine a cause of death of any of the 3 dead infants, and it was impossible to determine a means of death. I asked the district attorney's office if they could point me to cases in which somebody, on evidence as speculative as exists in this case, was charged and convicted of murder. And I was pointed to a case which I believe is the lead case on speculative evidence and charging someone with murder in the absence of any evidence of cause of death. And the case is Commonwealth versus Ned Warney. It's a 1985 SJC case, 396 Mass 342. And the case involved a victim who had been tied up and bound in duct tape and rope, hidden in the trunk of a car, and the car was then hidden, and the body was found many, many months later, and it was impossible to determine a cause of death. But in addition to that evidence of obvious foul play by somebody, there was also evidence in that case of bloodstains found on the carpet of the defendant's home. There were inculpatory statements. There was a wealth of evidence, circumstantial but powerful, that supported the charge and ultimately the conviction of murder. But in this case, what we have is at most evidence that 1 or 2 babies survived for some unknown period of time. Mr. Bradley commented that Ms. Murray told the police that one of the infants, not the one that she had acknowledged was alive for 1 to 3 weeks. That's not the case. What actually happened in these police interviews is that the police repeatedly put words into her mouth, and she simply agreed with whatever they asked because it was her belief that if she went along with them, she'd go home. So it's true that there are portions of that interview where she says, in response to a police question, that gave her the answer. Yes, the baby was alive for 1 to 3 weeks. There's other parts of the same interview in which she says the baby was alive for less than a day. There's another part of the interview where she says it might have been 3 days. There's another part of the interview where she says it might have been 3 months. The story changes just constantly depending upon what she thinks the police are asking her to agree to. But the only evidence that the Commonwealth has at this point is that that baby was alive for some period of time. The baby with the umbilical cord is not the subject of a murder charge. So there's one other baby who was found with some clothing on, and that clothing is the only evidence that the Commonwealth has to infer that that baby was alive. And I'd argue that that in and of itself doesn't establish anything, because it's completely conceivable that a woman would suffer a stillborn, want to hold that baby, want to spend some time with that baby, and put clothes on it. But even if you assume that that baby also was alive for some period of time, there's no evidence of how these children died. There's no evidence that Miss Murray did anything to cause their deaths. There's no evidence of any medical emergency that she should have known about, that should have prompted her to call 911 or get medical help. There's none of that. There is simply arguably evidence that two children were alive for some unknown period of time and for some unknown reason died. And that's the case. And I'd argue, Your Honor, that there is not a single case in Massachusetts that supports a conviction of murder on evidence so speculative and so weak. And that the appropriate thing would have been to wait for the medical examiner's report to be completed to determine if, in fact, there's any additional evidence that supports these charges, because right now there is none. The evidence of severe harm to the two younger children is clear. And the issue in that, on those charges, is what the state of mind is with Ms. Murray is. Because these children were not the only ones who were never out of that house. She lived there too. The house of squalor that the media has described, that the Commonwealth has provided so much information about, that was her home. She lived in those conditions for years and hardly ever left the house. I think there is zero risk of flight in this case. The harm that Ms. Murray could have caused has been caused. There's no risk to the public of her being released, and I'd ask the court to consider releasing her to home detention on electronic monitoring.
What's going to hold her without bail based on the seriousness of the allegation and the potential consequences of the conviction? Is there any request for examinations for competency or responsibility at this time, Mr. Halpern?
No, Your Honor.
Commonwealth making any such request at this time?
No, Your Honor.
Next court date.
You know, I think the reality is that until the medical examiner's work is done, this case is really in limbo. And, you know, it's an issue that impacts bail as well. I have another case in Suffolk County in which I waited close to a year on a vehicular homicide.
So you've received already all the other investigative reports?
No, I haven't received.
We should continue with some compliance and discovery, any motions that may be necessary, any DNAs, any motions to suppress, can all be done absent. And those all have nothing to do with the medical examiner's reports per se, so we can move this along without waiting until the medical examiner's reports, right?
Yeah, there may be additional motions that stem once I get that evidence, but I agree.
All right, so we'll have a pretrial conference date approximately 30 days out. Do you have an agreement on a date?
February 4th, acceptable?
All right, February 4th for pretrial conference. I'll hold it without bail. I'll hold it without bail without prejudice at